In this module, I want to focus on the powers of the federal government. Of course, the federal government creates three branches. I'm going to first talk about the powers of the judicial branch. These are created in Article 3 of the Constitution. Then second, I'm going to talk about the powers of the legislative branch, the powers of Congress created in Article 1 of the Constitution. And then finally, I'll talk about the powers of the president in the executive branch, and those are created by Article 2 in the Constitution. So let me begin first with the powers of the judicial branch of government. As I said, it's Article 3 of the Constitution that creates the Supreme Court and that gives Congress the authority to create the lower federal courts. In the first Judiciary Act in 1789, Congress created federal district court and federal courts of appeals, and they have existed ever since. A basic principle is that a federal court can hear a case only if there's both constitutional and statutory authority. There must be constitutional authority in the sense that it must be a matter that Article 3 authorizes the federal courts to hear. There must be statutory authority in the sense that there has to be a federal law that authorizes the federal courts to hear the case. This, of course, is very different than when it comes to state courts. State courts can hear anything, federal claims and state claims, civil arena, unless there's a federal statute creating exclusive federal court jurisdiction. What I want to focus on is several topics with regard to the federal judicial power. A here is the requirement for cases and controversies. Article 3, Section 2 of the Constitution defines the federal judicial power using two words, cases and controversies. The Supreme Court has interpreted these words as giving rise to a series of limits on the federal judicial power. These limits are sometimes called justiciability doctrines. There are four justiciability doctrines, and all must be met in order for any federal court at any level to hear the case. In other words, to fit with what I've been saying, a federal court can hear a case only if there's constitutional authority. The Supreme Court has said the words cases and controversies that are used in Article 3, Section 2 define that constitutional authority, and the court is derived from, interpreted these words as giving rise to these four justiciability doctrines. Point one, the first justiciability doctrine is standing. Standing here, of course, has nothing to do with the physical posture of the litigants. Rather, standing is the question of whether the plaintiff is the proper party to bring a matter to the court for adjudication. Standing is the question of whether the plaintiff is the proper party to bring a matter to the court for adjudication. The Supreme Court has said that of all the justiciability requirements, standing is the most important. In order for a plaintiff to have standing, several requirements all must be met. So under point one, standing, sub A, injury. The plaintiff must allege and prove that he or she has been or imminently will be injured. A couple of things to know about this injury requirement. One thing that's important to know is that the plaintiff may present only personally suffered injuries. The plaintiff may present only personally suffered injuries. Let me give you a couple of examples, cases you might have read in law school. One is a case called Sierra Club versus Morton from 40 years ago. Disney wanted to build a ski resort in a beautiful area known as Mineral King Valley. The Sierra Club sued to stop construction. The Supreme Court, though, ruled that the Sierra Club lacked standing because they failed to allege that any of their members had ever used Mineral King. Justice Byron White, who was then on the Supreme Court, is quoted in the book The Brethren as saying, "Why didn't they just have one goddamn member walk through the park?" Well, sure enough, on remand, they amended their complaint to say that some of their members had used Mineral King, and then the court said they had standing because then they had alleged a personally suffered injury. Another illustration of this, a more recent case, is Clapper versus Amnesty International from 2013. Congress amended the Federal Foreign Intelligence Surveillance Act to allow the National Security Agency to intercept communications between those in the United States and those in designated foreign countries. In other words, the NSA could literally listen to the conversations and read the emails. A challenge was brought to this by a group of lawyers and journalists and business people who said that they regularly communicate with those in foreign countries, and they expressed concern that their communication be chilled out of fear that it would be intercepted. They said that the only way they could communicate with their clients or their sources would be to travel to the foreign countries. But the Supreme Court ruled 5-4 that these plaintiffs lacked standing. The Supreme Court said the plaintiffs could not show that their communications had been intercepted or were likely to be intercepted. The NSA doesn't tell people when it's intercepting their communications. The court said that the plaintiffs couldn't show a personally suffered injury and thus no standing. The other thing to know about the injury requirement, the second thing I want to mention about it, is that a plaintiff who is seeking injunctive or declaratory relief must show a likelihood of future harm. Plaintiff who is seeking injunctive or declaratory relief must show a likelihood of future harm. This was the holding initially. In another case you might have studied, City of Los Angeles versus Lyons. Adolph Lyons, a 24-year-old African-American man, was stopped by Los Angeles police officers throwing a burnt-out taillight. The officer slammed Lyons' hands above his head. Lyons complained that the keys in his hand were cutting into his scalp, into his palm. An officer then applied a chokehold on Lyons and rendered him unconscious. Lyons awoke, spitting blood and dirt. He had urinated and defecated. The officer gave Lyons a traffic ticket and let him go. Lyons did some research and discovered at that point 16 people in Los Angeles, almost all like him, African-American men, had died from police use of the chokehold. Lyons sued the city of Los Angeles for an injunction to keep the officers from using the chokehold except where necessary to protect the officer's life or safety. But the Supreme Court ruled that Lyons lacked standing. The Supreme Court said that Lyons could not show that it was likely that he personally be choked in the future. The court said that a plaintiff like Lyons, who's seeking an injunction or a declaratory judgment, must show a likelihood of future personal injury. So that's A with regard to standing, the requirement for injury. Sub B with regard to standing is causation and redressability. The plaintiff must allege and prove that the defendant caused the injury so that a favorable federal court decision is likely to remedy the injury. The plaintiff must allege and prove that the defendant caused the injury so that a favorable federal court decision is likely to remedy the injury. The Supreme Court often has said that the core of Article 3 is a prohibition against federal courts issuing advisory opinions. If a federal court ruling for the plaintiff would have no effect, then it's just an impermissible advisory opinion. The Supreme Court says, in order for a plaintiff to have standing, the plaintiff has to show the court that a favorable federal court ruling is likely to remedy the harm suffered. The court says the best way to be sure of that is to know that the defendant is the cause of the injury. To illustrate, let me again use a case that you might have studied. A case called Simon versus Eastern Kentucky Welfare Rights Organization from 1975. There's a federal statute that says in order for a hospital to have tax status, it has to provide free care to indigents. The Internal Revenue Service adopted a regulation that hospitals could keep their tax status without providing free care to indigents. Some poor people went to a tax-exempt hospital. They requested free care and they were turned away. They sued the IRS to have the revenue rules struck down as being inconsistent with the federal statute. But the Supreme Court ruled that they lacked standing. The Supreme Court said the plaintiffs could not show that even if the revenue were struck down, that more free care would be available. The court said hospitals might choose to give up their tax status rather than provide more free care to indigents. The court said the plaintiffs can't show that the revenue rule, as opposed to the economics of the situation, is the cause of the lack of free care. Therefore, no standing. Sub C under point 1 with regard to standing is that no third-party standing is allowed. When I say no third-party standing is allowed, I mean that the plaintiff cannot present the claims of others, of third parties who are not before the court. I already said to you, a plaintiff can present only personally suffered injuries. That would explain why the plaintiff can't present the claims of others, of third parties who are not before the court. However, there are a few exceptions where third-party standing is permitted. That is, a plaintiff who meets the other standing requirements may present the claims of a third party if any one of these exceptions is present. I want to emphasize what I just said. In order for there to be third-party standing, the plaintiff must meet all of the other standing requirements, and one of these exceptions must be present. I think the most important exception with regard to third-party standing is the first that I want to talk about, and that's the exception that third-party standing is permitted if there's a sufficiently close relationship between the plaintiff and the injured third party. Third-party standing is permitted if there's a sufficiently close relationship between the plaintiff and the injured third party. Or as I think this is best understood, third-party standing is allowed if there's a sufficient identity of interest that the plaintiff can be trusted to adequately represent the interests of the third party. Let me give you an example. The doctor-patient relationship. Many of the challenges to state laws restricting access to abortion were brought by doctors asserting the rights of their patients. Laws restricting abortion inflicted an injury on the doctors, a loss of business. But it's unlikely that any court would strike the laws down on that basis. So the doctors chose to present a stronger constitutional claim, the rights of their patients. There's a sufficiently close relationship, a sufficient identity of interest to allow this. Another example is a case you might remember. You studied equal protection law, Craig versus Boren. Oklahoma had a law that said that women could buy low alcohol beer, so-called 3-2 beer, at age 18, but men could not buy the low alcohol beer until age 21. Well, you may not know about the case, is that the plaintiffs were bartenders themselves over the age of 21 who were asserting the rights of the male customers who were between 18 and 21. Now, I don't think it's that the court thought that there was a close relationship between bartender and customer. I think what the court was saying is there's a sufficient identity of interest between bartender and customer. The bartender wants to sell the beer, the customer wants to buy the beer. We can trust the bartender to adequately represent the interests of the third parties, the customers, the men between 18 and 21. In light of this exception, it was surprising that several years ago, the Supreme Court ruled that a father lacked standing to sue on behalf of his daughter to challenge the words "under God" in the Pledge of Allegiance is violating the Establishment Clause of the First Amendment. The case was Elk Grove Unified School District versus Newdow in 2004. Michael Newdow brought a lawsuit on behalf of his daughter, arguing that to have "under God" in the Pledge of Allegiance in public schools was an impermissible establishment of religion. But the Supreme Court ruled that Newdow lacked standing. The Supreme Court said the mother has legal custody of the girl. The mother does not want the lawsuit to go forward. Therefore, Newdow, despite being the parent, despite being involved in his daughter's upbringing, lacked standing. I've always thought that the late Robin Williams had the best solution to this case and this issue. He said, just change the Pledge of Allegiance, say, "one nation under Canada." Well, that's the first exception with regard to third-party standing, where there's a close relationship, an identity of interest between the plaintiff and the third party. A second exception that exists with regard to third-party standing is that third-party standing is allowed if the injured third party is unlikely to be able to assert his or her own rights. Third-party standing is allowed if the injured third party is unlikely to be able to assert his or her own rights. If there's good reason to believe that the injured third party can't come to court to protect itself, then we're going to allow someone who meets the other standing requirements to present those claims. A third and final exception where third-party standing is permitted is called organizational standing, or sometimes this is synonymously referred to as associational standing. Organizational standing, associational standing, but when can an organization assert the rights of members? Well, an organization or an association can assert the rights of the members if three requirements are met. First, the individual members must have standing to sue. There must be an individual member of that organization who would have standing in order for the organization to be able to sue. The second requirement for organizational standing is that the interest must be germane to the organization's purpose. The interest must be germane to the organization's purpose. The interest in the lawsuit must relate to what the organization is about. And finally, with regard to organizational standing, neither the claim nor the relief requested must require the individual's participation. Neither the claim nor the relief requested must require the individual's participation. From a common sense perspective, is there any reason to believe that the claims of the members of the organization or the relief that they'll be given vary so much that this should be litigated on an individual basis rather than by the organization? So that's sub C with regard to standing, the prohibition of third-party standing and the three exceptions to it. Finally, with regard to standing, sub D, no generalized grievances are allowed. No generalized grievances are allowed. The Supreme Court frequently has said that plaintiffs who assert generalized grievances lack standing. But this is misleading phrasing. Something is not a generalized grievance just because a large number of people or even everyone suffers the injury. Generalized grievance refers to a particular type of claim. What's key to remember here is that the plaintiff must not be suing solely as a citizen or as a taxpayer interested in the government follow the law. The plaintiff must not be suing solely as a citizen or as a taxpayer interested in the government follow the law. An example of a case you might have read, United States versus Richardson in 1973. Article 1 of the Constitution says that Congress shall give a regular statement and account of all expenditures. Richardson brought a lawsuit. He argued that the statute that provides for the secrecy of the CI budget violates the Statement and Accounts Clause. The Supreme Court, though, ordered Richardson's suit dismissed for lack of standing. The court said Richardson's only claims are as a citizen interested in the government follow the law and as a taxpayer interested in the government not spend his tax dollars in violation of the Constitution. The court said when the plaintiff's only claims are as a citizen or as a taxpayer, that's a generalized grievance, no standing. There is one and only one exception where taxpayer standing is permitted. It's a narrow exception. That is, taxpayers have standing to challenge government expenditures pursuant to a statute as violating the Establishment Clause. Taxpayers have standing to challenge government expenditures pursuant to a statute is violating the Establishment Clause. This was the holding of Flast versus Cone in 1969. Congress passed, the president signed a bill to have the federal government give direct financial aid to parochial schools. In other words, religious schools could get money from the federal government under the statute. A taxpayer brought a challenge saying that this violated the Establishment Clause of the First Amendment. It's impermissible establishment of religion. The Supreme Court ruled that the taxpayer had standing. The Supreme Court explained that the Establishment Clause was meant to be a limit on Congress's taxing and spending power. Therefore, taxpayers do have standing when they're asserting a violation of the Establishment Clause. But in the years since Flast versus Cone, the Supreme Court has continually narrowed taxpayers' standing to challenge Establishment Clause violations. One example of narrowing this was a case in 1981, Valley Forge Christian College versus Americans United for Separation of Church and State. The federal government gave her $500,000 of property to a religious college in Pennsylvania. Taxpayers brought a challenge. They said, we have standing because we're asserting a violation of the Establishment Clause. But the Supreme Court ruled no standing. The Supreme Court said, taxpayers have standing to challenge government expenditure of money is violating the Establishment Clause. But taxpayers do not have standing to challenge government grants of property is violating the Establishment Clause. Another case that limited Flast versus Cone was Hine versus Freedom from Religion Foundation in 2006. When George W. Bush became president, one of his first acts was to create an Office of Faith-Based Programs. The goal of this office was to facilitate churches, synagogues, mosques being able to directly receive federal social service money for things like child care or alcohol and drug rehabilitation. President Bush paid for the Office of Faith-Based Programs from general executive revenue. A challenge was brought. The challenger said, this is the government using money in a way that violates the Establishment Clause. Taxpayers' standing should exist. But the Supreme Court ruled 5-4 against allowing taxpayer standing. The Supreme Court said, taxpayers have standing to challenge government expenditures pursuant to a statute is violating the Establishment Clause. Taxpayers do not have standing here because a challenge for money taken from general executive revenue. The final case that limited taxpayers' standing is just a few years ago, Arizona School Tuition Organization versus Wynn. Arizona passed a law that allowed individuals to get up to $500 in tax credit. They gave money to a, quote, school tuition organization. Almost all of this money went to Catholic schools and evangelical Christian schools. A challenge was brought that this violated the Establishment Clause. The Federal Court of Appeals found that the taxpayers had standing and found that the Arizona law was unconstitutional. The Supreme Court, though, reversed, again in a 5-4 decision. The court said taxpayers have standing to challenge government expenditure of money, but taxpayers don't have standing to challenge government giving of tax credits. Now, I could question all of these distinctions. Why standing to challenge expenditures, but not property? Why standing to challenge money under a statute, but not from general executive revenue? Why standing to challenge spending, but not tax credits? Aren't they really the same? But these are the distinctions the court has given, and thus the exception where taxpayer standing is permitted is, as I said, taxpayers are standing to challenge government expenditures pursuant to a statute is violating the Establishment Clause. And that finishes point 1, standing, the first justiciability requirement. Still under major subpoint A with regard to the federal judicial power, the requirement for cases and controversies, my second point is ripeness. Ripeness is the second justiciability requirement. Ripeness is best understood as asking the question, may the federal court grant pre-enforcement review of a statute or regulation? May the federal court grant pre-enforcement review of a statute or regulation? The usual way of challenging a law is to violate it, be prosecuted, and then argue as a defense that the law is unconstitutional or otherwise invalid. But sometimes people don't want to have to violate a law in order to challenge it. They want a declaratory judgment that the law is unconstitutional or otherwise invalid. But whenever a federal court is asked to issue a declaratory judgment, it has to be sure that there really is a case or controversy. This is when ripeness issues usually arise. So one way to spot ripeness issues, say on constitutional law exams, is there a request for a declaratory judgment? The Supreme Court has said, in assessing ripeness, it will look at 2 criteria. Sub A, the hardship that the plaintiff will suffer without pre-enforcement review. The hardship that the plaintiff will suffer without pre-enforcement review. Obviously, the greater the hardship that the plaintiff will suffer without pre-enforcement review, the more willing the court's going to be to decide the request for a declaratory judgment. In sub B is the fitness of the issues and the record for judicial review. The fitness of the issues and the record for judicial review. Does the federal court have before it all that it needs to effectively decide the issue? Is there any reason why the federal court is better off waiting for an actual prosecution and then deciding the case in that context? Let me illustrate this with a very famous case about ripeness, one you well may have read in law school. It's a case called Abbott Laboratories versus Gardner. The Food and Drug Administration adopted a rule that all prescription drug advertisements and labels shall state the generic name of the drug. drug companies brought a challenge to this. They argued that the FDA lacked the authority to adopt the rule under the Food, Drug, and Cosmetic Act. The FDA moved to dismiss the case on ripeness grounds. The FDA said to the federal court, no drug company has yet been prosecuted for violating the rule. The FDA said, federal court, wait until there's an actual prosecution, and then you can decide the issue. The Supreme Court said in assessing ripeness, it will look at two criteria. First, what hardship would the plaintiff suffer without pre-enforcement review? The Supreme Court said the hardship would be great. Either drug companies had to violate the rule and risk criminal penalties were upheld, or they had to comply with the rule and risk wasting millions of dollars if it was later invalidated. The court said it would next look to the fitness of the issues in the record for judicial review. The court said, this is purely a question of law. Does the federal court have the legal authority, does the FDA have the legal authority under the statute to promulgate the regulation? The court said, there's nothing to be gained by waiting for an actual prosecution. A federal court can just decide that question of law. And so the court found that the case was ripe for review. Point 3, mootness is the third justiciability requirement. Mootness. If events after the filing of the lawsuit end the plaintiff's injury, the case shall be dismissed as moot. If events after the filing of the lawsuit end the plaintiff's injury, the case shall be dismissed as moot. A plaintiff must present a live controversy, an ongoing injury at all stages of the federal court proceedings. If anything happens while the case is pending to end the plaintiff's injury, it has to be dismissed as moot. However, there are a few exceptions to the mootness doctrine. These are situations where the plaintiff's injury is over, but nonetheless, the federal court can decide the case. I think the most important of these exceptions is sub A, the exception for wrongs capable of repetition but evading review. Wrongs capable of repetition but evading review. There are some injuries that will happen over and over again, but invariably they are of such short duration that the injury is over before the federal court proceedings are completed. The Supreme Court has said if it's a wrong capable of repetition, and there must be at least a chance that it could happen to that plaintiff again, but it would always evade review, then the federal court can decide the question even though the plaintiff's injury is over. To understand, to remember, wrongs capable of repetition but evading review, just think of Roe versus Wade. Roe filed a lawsuit in 1970 challenging the Texas statute prohibiting abortions. At the time she filed her lawsuit, she was pregnant, she was in her first trimester, and she was seeking an abortion. By the time the Supreme Court decided her case in 1973, she was obviously no longer pregnant. The state of Texas moved to dismiss on mootness grounds. The Supreme Court acknowledged that her injury was over, but the court said that nonetheless it could decide the constitutional issue because of a wrong capable of repetition but evading review. It was a wrong capable of repetition because she could become pregnant again in the future and once more seek an abortion. And it would always evade review because the time for human gestation is inherently shorter than the time for human litigation. Sub B, another exception to mootness, is called voluntary cessation. Voluntary cessation. If the defendant voluntarily halts the offending practice, but is free to resume it at any time. The case will not be dismissed as moot. If the defendant voluntarily halts the offending practice, but is free to resume it at any time, the case will not be dismissed as moot. Example: imagine that an employer is sued in hiring for using a test. An employer is sued for using a test in hiring that's alleged to be racially discriminatory. Assume that as soon as the lawsuit is filed against the employer says, "I voluntarily agree, I won't use this test anymore." But legally, the employer is free to resume using the test anytime the employer wants. That case will not be dismissed as moot, so long as it is just voluntary cessation. So long as the defendant can resume the practice anytime the defendant wants, the case will not be dismissed on mootness grounds. Finally, sub C, there's an exception to the mootness doctrine for class action suits. The final exception with regard to mootness is for class action suits. If the named plaintiff in a class action has his or her claim become moot, the class action will not be dismissed so long as one member of the class has an ongoing injury. If the named plaintiff's claim in a class action becomes moot, a class action will not be dismissed so long as one member of that class has an ongoing injury. And that's the mootness doctrine and its exceptions. Finally, point 4 under subunit A about cases and controversies focuses on the political question doctrine. The final justiciability doctrine, point 4, is the political question doctrine. The political question doctrine refers to allegations of constitutional violations that the federal courts will not adjudicate. The political question doctrine refers to allegations of constitutional violations that the federal courts will not adjudicate. The Supreme Court has said that there are some constitutional claims that are left to the political branches, the elected branches of government, to resolve. There are 4 important examples of cases that are dismissed as, quote, non-justiciable political questions. With regard to the political question doctrine, A, the first example, is cases under the Republican form of government clause are non-justiciable political questions. Cases under the Republican form of government clause are non-justiciable political questions. The Republican form of government clause refers to a provision in Article 4, Section 4 of the Constitution that says that the United States shall guarantee to each state a Republican form of government. I've called this the Republican form of government clause. Sometimes people call it the guarantee clause. Now, contrary to wishes of past occupants in the White House, the Republican form of government clause has nothing to do with political party. Rather, the framers of the Constitution thought that a Republican form of government was one where people would elect representatives, and representatives would then make the laws. Ever since the 1840s, in a case called Luther versus Borden, the Supreme Court always has said that cases under the Republican form of government clause are non-justiciable political questions. Example: imagine that a state adopts a new law through the initiative process. Imagine that a challenge is brought to that law on the ground that it violates the Republican form of government clause. The claim is that this is direct democracy. That's not a Republican form of government. Correct answer: that case would be dismissed, because cases under the Republican form of government clause always have been dismissed by the Supreme Court going back to the 1840s. Sub B, second example of what's a political question: challenges to the president's conduct of foreign policy are non-justiciable political questions. Challenges to the president's conduct of foreign policy are non-justiciable political questions. is an example. In the late 1960s and early 1970s, over 24 lawsuits were brought arguing that the Vietnam War was unconstitutional because the president was waging war without a congressional declaration of war. Invariably, these lawsuits were dismissed as political questions because they would challenge the president's conduct of foreign policy. Another important example, one that you might have read in law school, was the case of Goldwater versus Carter. President Jimmy Carter rescinded the United States treaty with Taiwan as part of recognizing the People's Republic of China. Senator Barry Goldwater brought a lawsuit challenging this. He said, just as the Senate has to approve the making of a treaty, so does the Senate have to approve the rescission of a treaty. But the Supreme Court ordered Goldwater's suit dismissed. The Supreme Court said, since it was a challenge to the president's conduct of foreign policy, it was a non-justiciable political question. Sub C, challenges to the impeachment and removal process are non-justiciable political questions. Challenges to the impeachment and removal process. The key case here was 1993. It was ironically titled Nixon versus United States. The Nixon in this case was Walter Nixon. He was a federal district court judge from Mississippi who had been impeached by the House of Representatives. It probably reflects my age, but I find it's a delicious irony that the only Supreme Court case in history dealing with impeachment still had the title Nixon versus United States. After Walter Nixon was impeached by the House of Representatives, the case went to the Senate for a trial. The Senate formed a committee to hear the evidence against Walter Nixon and make recommendations to the entire body. Nixon objected to this. He said the whole Senate should have to sit and try him. The Supreme Court ordered his case dismissed as a political question. The court said challenge the impeachment and removal process are non-justiciable political questions. Finally, sub D, challenges to partisan gerrymandering are non-justiciable political questions. Challenges to partisan gerrymandering. Partisan gerrymandering is where the political party that controls the legislature draws election districts to maximize say seats for that party. It's where the political party that controls the legislature draws election districts to maximize say seats for that party. It's where the Republican-controlled state legislature in Texas draws election districts to maximize say seats for Republicans. It's where the Democratic-controlled state legislature in California draws election districts to maximize say seats for Democrats. In two cases, in 2004 and 2006, Veith versus Jubelier and Lulac versus Perry, the Supreme Court said that challenges to such partisan gerrymandering are non-justiciable political questions. So that then completes major subpoint A with regard to the federal judicial power, the requirement for cases and controversies. Remember, for any federal court at any level, federal district court, United States Court of Appeals, United States Supreme Court to hear the case, the plaintiff must have standing, the case must be ripe for review, it must not be moot, and it must not pose a political question. Still talking about the federal judicial power, major subpoint B, Supreme Court review. Obviously, in order for the Supreme Court to hear a case, all the justiciability requirements that I just reviewed must be met. Additionally, there are a few other rules with regard to Supreme Court review that are important to note. Point one, virtually all cases come to the Supreme Court by a writ of certiorari. Virtually all cases come to the Supreme Court by a writ of certiorari. Where the statutes defining Supreme Court jurisdiction provide for review by certiorari, the court has complete discretion whether or not to hear the case. If there's 4 justices who want to hear it, the court grants certiorari. If there's not 4 votes to hear certiorari, then the court doesn't hear the case. To be more specific here, sub A, all cases from state courts go to the United States Supreme Court by writ of certiorari. All cases from state courts go to the Supreme Court by writ of certiorari. If you as a lawyer lose a case in your state highest court, say your state Supreme Court, and you want United States Supreme Court review, it's only by certiorari, discretionary review. Sub B, all cases from United States Courts of Appeals go to the Supreme Court by writ of certiorari. All cases from United States Courts of Appeals. So, if someone loses a case, say in the United States Court of Appeals for the Ninth Circuit, and they want Supreme Court review, and it's understandable why they try, given how often the Supreme Court reverses the Ninth Circuit, it's only by certiorari, discretionary review. Sub C, appeals exist only for Supreme Court review of decisions by 3-judge federal district courts. Appeals exist only for Supreme Court review of decisions by 3-judge federal district courts. Where the statutes defining Supreme Court jurisdiction provide for review by appeal as opposed by certiorari, the Supreme Court has complete discretion whether to hear. When it says for appeal, the court must take and decide the case. Where the statute says there's appeal to the Supreme Court is obligated to take the case, unlike certiorari, where it's discretionary review. In 1988, Congress revised the statutes defining Supreme Court jurisdiction to eliminate almost all appeal to the Supreme Court, so that now virtually everything comes by certiorari. There's only one instance in which there's still appeal to the Supreme Court, where the Supreme Court is obligated to take the case, and that's where there's the unusual procedure of a 3-judge federal district court. There are some federal statutes that have this unusual procedure and say that cases under them will be heard by a 3-judge federal district court. An example, the Voting Rights Act says that certain cases under it are heard in a 3-judge federal district court. Another famous example, the McCain-Feingold Campaign Finance Reform Act, the Bipartisan Campaign Finance Reform Act, said that any challenges to its constitutionality would be heard by a 3-judge federal district court. Whenever there's a 3-judge federal district court and appellate review is sought, the case skips the United States Court of Appeals, goes right from the 3-judge federal district court to the United States Supreme Court. And Supreme Court review is by appeal. The Supreme Court is required to take and decide the case. Finally, sub D under point 1, and that is the Supreme Court has original and exclusive jurisdiction to hear suits between state governments. The Supreme Court has original and exclusive jurisdiction to hear suits between state governments. Article 3, Section 2 of the Constitution delineates a few instances in which the Supreme Court may exercise original jurisdiction. That is, be the court where the matter is initially filed. And so Article 3, Section 2 says the Supreme Court can exercise original jurisdiction in cases involving ambassadors or public ministers or where a state is a party. In fact, in the landmark case of Marbury versus Madison in 1803, the Supreme Court said Congress cannot expand the original jurisdiction of the Supreme Court. The original jurisdiction is limited to just that enumerated in Article 3. However, under current statutes, there is only one instance in which the Supreme Court will ever exercise original jurisdiction. And then it has exclusive jurisdiction. It's the only court in the country that can hear the matter. That's for suits between state governments. If California wants to sue Arizona in a water rights dispute, California must file that lawsuit initially right in the United States Supreme Court. The Supreme Court has original and exclusive jurisdiction to suits between state governments. The reason is obvious. It's thought that the courts in any specific state would be too biased, be perceived as too biased to be able to hear the matter. Point 2 under sub B. Generally, the Supreme Court may hear a case only after there's a final judgment of the highest state court, of a United States Court of Appeals, or of a 3-judge federal district court. Generally, the Supreme Court may hear a case only after there's a final judgment of a highest state court, a United States Court of Appeals, or a 3-judge federal district court. This is sometimes referred to as the final judgment rule. The final judgment rule is just a reminder that there's generally no interlocutory review in the Supreme Court. If a matter is being litigated in state court, then all state appeals must be tried before the Supreme Court can hear the case. If a matter is being litigated in federal court, all federal appeals must be used before the Supreme Court can hear the matter. Finally, point 3 under subunit B. For Supreme Court review of state court decisions, there must not be an independent and adequate state law ground of decision. For Supreme Court review of state court decisions, there must not be an independent and adequate state law ground of decision. This is a long rule. It's a complicated one. Here's the way I think best to understand it. If a state court decision rests on 2 grounds, one federal law and one state law, if Supreme Court reversal of the federal law ground will not change the result, then the Supreme Court can't hear the case. If a state court decision rests on 2 grounds, one federal law and one state law, if Supreme Court reversal of the federal law ground will not change the result, then the Supreme Court can't hear the case. Here's some examples to understand this and remember this by. One example. Imagine hypothetically that a person is beaten up by some Los Angeles police officers. And imagine that the victim sues the officers in California State Trial Court. The victim brings 2 claims. One is a federal constitutional claim. The Supreme Court has said that excessive police force violates the 4th Amendment. The other is a state law battery claim. Imagine that the jury in the state trial court rules in favor of the plaintiff on both claims. The jury says that the plaintiff is entitled to $100,000, medical bills and pain and suffering, under either the federal claim or under the state claim. But the plaintiff is not entitled to $200,000. The defendant police officers appeal through the California state system and they lose. They then want United States Supreme Court review. It's key to remember here that the United States Supreme Court can hear and decide only federal law issues. State courts get the last word on purely state law questions. Can the Supreme Court hear or review the federal ground of decision? Can the Supreme Court grant review to see if the state court made a mistake as to federal law? The answer is no, there cannot be Supreme Court review. Because even if the Supreme Court reverses on the federal law ground of decision, that's not going to change the result. The plaintiff will still win and win the identical amount of money, $100,000, based on the state law ground of decision. Or to put it another way, since the state law ground of decision is independent of federal law and adequate to support the result, there can be no Supreme Court review. Another example. Imagine that there's a factory that emits a great deal of pollution. Imagine that the members of a neighborhood want to bring a lawsuit to stop the pollution. They file a lawsuit in state trial court and they raise 2 claims. One is a federal law claim under the Federal Clean Air Act. The other is a state law claim for nuisance. It's under state tort law. Imagine the state trial court judge says, plaintiffs win. They're entitled to their injunction either under federal law or under state law. The factory appeals to the state system and it loses. Now the factory wants the United States Supreme Court review. The factory wants to argue to the Supreme Court that the state court got it wrong with regard to the meaning of the Clean Air Act. Can the Supreme Court grant review on that federal law issue about the Clean Air Act? No, because even if the Supreme Court reverses on the federal law ground of decision, the plaintiffs will get exactly the same injunction based on state law. Once more, since state law is independent of federal law and adequate to support the result, there can be no Supreme Court review. Finally, with regard to the federal judicial power, major subpoint C, lower federal court review. Now, obviously, in order for a lower federal court to hear a case, all the justiciability requirements that I mentioned earlier must be met. But I want to talk about a couple of other things about lower federal court review. Point one, federal courts and state courts cannot hear suits against state governments. Federal courts and state courts cannot hear suits against state governments. Sub A under point one is the principle of sovereign immunity. The principle of sovereign immunity. Couple of points under this. First, the 11th Amendment bars suits against state governments in federal court. The 11th Amendment bars suits against state governments in federal court. It doesn't matter whether the plaintiff is a citizen of that state or of another state. It doesn't matter whether it's a claim for money or for an injunction. Generally, a state government cannot be named as a defendant in a federal court suit. The other point under the principle of sovereign immunity, the second, is that sovereign immunity prevents suits against state governments in state courts or in federal agencies. It's sovereign immunity that prevents suits against state governments in state courts or in federal agencies. This was the holding of Alden versus Maine in 1999. Probation officers in the state of Maine claimed that they were owed overtime pay by the state. They said they were owed money by the state, their employer, under the Federal Fair Labor Standards Act. The state of Maine moved to dismiss the suit. The probation officers initially filed it in federal court, and the federal court dismissed based on the 11th Amendment. So the probation officers refiled it in state court. But the United States Supreme Court ruled 5-4 that state governments have sovereign immunity and cannot be sued state court even on a federal claim. Notice then that the probation officers had a federal statutory right to the money, but there was no place, no forum where they could sue. Not federal court, not state court, not a federal agency. Sub B are exceptions to sovereign immunity. Sub B, with regard to point one, exceptions to sovereign immunity. There are 4, but only 4 situations where state government ever can be named as a defendant. The first exception under sub B is waiver. A state may waive its sovereign immunity and may consent to be sued. However, the waiver must be explicit. The Supreme Court has said there's no such thing as an implied or constructive waiver of sovereign immunity. The second exception is more complicated. It's that states may be sued pursuant to federal statutes adopted by Congress under Section 5 of the 14th Amendment. but Congress cannot override sovereign immunity using any of its other legislative powers. States may be sued pursuant to statutes adopted by Congress under Section 5 of the 14th Amendment. But Congress cannot override sovereign immunity using any of its other powers. To explain, Section 5 of the 14th Amendment authorizes Congress to adopt laws to enforce the 14th Amendment. The Supreme Court has said, since the 14th Amendment came after the 11th Amendment, Congress, when it legislates under Section 5, can override state sovereign immunity. Important example. Title VII of the 1964 Civil Rights Act prohibits employment discrimination on the basis of race, or gender, or religion. It was applied to the states by Congress pursuant to Section 5 of the 14th Amendment. The Supreme Court thus held that state governments can be sued for violating Title VII. But Congress cannot override sovereign immunity using any of its other powers. A law adopted under the Commerce Clause or under the spending power can't be used to override sovereign immunity. So, for example, the Federal Age Discrimination Employment Act was adopted by Congress under its Commerce Clause power, not under Section 5 of the 14th Amendment, and therefore it cannot be used to sue state governments. The third exception is that the federal government may sue state governments. The federal government may sue state governments. Sovereign immunity is no bar to the federal government suing a state government. And the fourth and final exception where state governments can be sued in bankruptcy proceedings. In bankruptcy proceedings. A state government cannot assert sovereign immunity as a defense in a bankruptcy proceeding. Example, imagine that a person who's filing for bankruptcy owes the state government unpaid taxes or unpaid student loan obligations from attending a state university. And imagine the person wants those debts discharged against the state government. The state government tries to assert sovereign immunity. The state government will lose there. The Supreme Court has said sovereign immunity does not protect a state in bankruptcy proceedings. Key, as I said, these are the four and the only four situations where state government can be named as a defendant. Finally, with regard to point 1 in sovereign immunity, sub C, state officers may be sued. Even where the state government cannot be sued, the state officer can be sued. State officers can be sued for injunctive relief. State officers can be sued for injunctive relief. If the state of California adopts an unconstitutional law and a lawyer wants that law enjoined to keep it enforced, the lawyer does not name the state of California as the defendant in the proceeding. Instead, what the lawyer does is identify the state officer who's responsible for carrying out that law and then get an injunction against that person, like the governor or the attorney general. State officers may be sued if they're personally liable. If the state officer is being sued and be personally liable, then sovereign immunity is no bar to suit. If the officer has a judgment against him or her, sovereign immunity doesn't bar the suit from going forward. Now, whenever a state officer, for that matter, a federal or local officer, is sued for money damages, whether he be personally liable, there's always some immunity as a defense, sometimes absolute, sometimes qualified immunity, but sovereign immunity does not bar the suit. But state officers cannot be sued where it's the state treasury that would be liable for retroactive damages. State officers cannot be sued where it's state treasury that would be liable for retroactive damages. In other words, if it's state treasury that will be legally liable to pay damages for past wrongs, then the suit can't go forward. The only exception to this is what's called indemnification. if a state or local government promises to indemnify its officer, that isn't something that would require the suit to be dismissed. Indemnification is thought of as a voluntary choice, a waiver by the state or local government, and therefore indemnification does not require that the case be dismissed. So that then is point one, explaining to you how state governments cannot be sued in federal court, or for that matter, in state court, subject to the four exceptions I mentioned. I want to conclude subpoint C, and for that matter, my discussion of the federal judicial power with point two, abstention. Abstention here has nothing to do with celibacy or teetotaling. Rather, abstention refers to instances where a federal court has jurisdiction but does not exercise it. The federal court has jurisdiction. All the justiciability requirements that I mentioned, all the jurisdictional requirements are met, but the federal court abstains. Abstention is generally not covered in constitutional law classes. I teach it in my upper level course on federal courts. And there are many abstention doctrines, but one is more important, I think, than the others. One is more likely than the others to potentially come up in a constitutional law class. And that's the principle that federal courts generally may not enjoin pending state court proceedings. Federal courts generally may not enjoin pending state court proceedings. Here's an easy example to remember this by. Imagine if the state of Texas adopts a law that prohibits the ownership or use of Barbary books on the grounds that they're obscenely boring. And imagine I'm in Texas and I'm using my Barbary books. A criminal prosecution is brought against me in Texas state court on the ground that I've got my Barbary books. I immediately go to federal court and I file a lawsuit. I want an injunction to halt Texas prosecution of me on the ground that it violates my free speech rights under the First Amendment. I want a declaratory judgment that the Texas law violates the Constitution. The federal court has jurisdiction. There's subject matter jurisdiction because this is unquestionably a federal question. All the justiciability requirements are met. But the federal court must abstain because federal courts may not enjoin pending state court proceedings. So in my discussion of the separation of federal powers, I began with the federal judicial power and have now completed that discussion. The second topic with regard to the federal powers and separation of powers is the federal legislative power. That's what I want to talk about next, the federal legislative power. Article 1 of the Constitution defines the powers of Congress. Major subpoint A, Congress's authority to act. Point 1, Congress may act only if there's express or implied authority. Congress may act only if there's express or implied authority. State and local governments possess what's called the police power. That is the authority of state and local governments to do anything except what's prohibited by the Constitution. But Congress lacks the police power. Congress can act only if there's express or implied authority. There is no general federal police power. In point 2, under subunit A, I want to talk about the necessary and proper clause. The necessary and proper clause is found in Article 1, Section 8 of the Constitution. It says that Congress can take all acts that are necessary and proper to carry out its authority. Long ago, in McCulloch versus Maryland, the Supreme Court said that this provides that Congress may choose any means not prohibited by the Constitution, to carry out its lawful authority. Congress may choose any means, not prohibited by the Constitution, to carry out its lawful authority. Easy example to remember this by. Article 1, Section 8 also says that Congress may raise an army and a navy. Imagine that Congress would decide to create a national bake sale as a way of raising money for the Army and the Navy. Congress would decide that a national bake sale is a good way to make a lot of dough for the federal government. I thought you'd get a rise out of that. Even though I'm on a roll, I'll stop. But notice, the Constitution says nothing about a national bake sale. Congress constitutionally could create one as a means not prohibited by the Constitution to carry out its powers. Congress can choose any means not prohibited by the Constitution that is reasonably designed to carry out the powers given to it under the Constitution. Point 3, the taxing, spending, and Commerce Clause powers. The taxing, spending, and Commerce Clause powers. Congress has many powers under Article 1, Section 8 of the Constitution. But from every perspective, the most important are Congress's powers to tax and spend and Congress's powers to regulate commerce. To be more specific, Sub A, Congress may tax and spend for the general welfare. Congress may create any tax to raise revenue and any spending program to expend it that Congress believes will serve the general welfare. A very important example of this was a case about the Patient Protection Affordable Care Act in 2012, National Federation of Independent Business versus Sebelius. The Patient Protection Affordable Care Act, often referred to as Obamacare, had as its goal making sure that almost all Americans had health insurance. One way that it did this was to say that every American had to purchase health insurance by the year 2014 or pay a tax. The Supreme Court, 5-4, upheld this as constitutional. The Supreme Court said the individual mandate was an exercise of Congress's taxing power. Individuals either had to purchase insurance or pay a tax penalty. The court said Congress has broad power to tax for the general welfare. Sub B under point 3 is the Commerce Clause. Article 1, Section 8 says that Congress has the power to regulate commerce with foreign nations, with Indian tribes, and among the states. As I'm sure you know, from 1937 to 1995, the Supreme Court broadly defined the scope of Congress's Commerce Clause authority. From 1937 until 1995, not one federal law was declared unconstitutional as exceeding the scope of Congress's Commerce Clause authority. But then, in 1995, the court decided United States versus Lopez. United States versus Lopez involved a federal criminal statute, the Gun-Free School Zone Act, that made it a federal crime for a person to have a gun within 1,000 feet of a school. The Supreme Court declared this law unconstitutional as exceeding the scope of Congress's power to regulate commerce among the states. The Supreme Court said that guns near schools have too attenuated a relationship to interstate commerce to allow Congress to regulate. In Lopez, the Supreme Court said that Congress can act under the Commerce Clause in any one of 3 circumstances. Little 1, Congress may regulate the channels of interstate commerce. The channels of interstate commerce are the places where commerce occurs. The highways, the waterways, the internet. These are the channels of interstate commerce. Little 2. Congress can regulate the instrumentalities of interstate commerce and persons or things in interstate commerce. Congress can regulate the channels of interstate commerce and persons or things in interstate commerce. Instrumentalities of interstate commerce are obviously the things that facilitate commerce. Trucks and planes, telephones, again, the internet. They're all examples of instrumentalities of interstate commerce. As to persons or things in interstate commerce, long ago, in the early 19th century, in Gibbons versus Ogden, Chief Justice John Marshall said, commerce refers to, quote, all forms of intercourse. Thus, Congress can regulate electricity or radio waves because they go across state lines. Congress can regulate stock or insurance because they go across state lines. Congress can regulate cattle or even people if they go across state lines. With regard to people, you might remember a case in the 1920s involves a federal statute that now seems to us anachronistically sexist, but it's still on the books. It's the Mann Act. It makes it a federal crime to take a woman across state lines for immoral purposes. An individual is convicted of this law for taking a woman from Nevada to California for, quote, purpose of making her his mistress. He argued to the Supreme Court that Congress shouldn't have the authority to regulate him under this law, under its commerce power. He said there was no allegation of prostitution or other commercial activity. But the Supreme Court ruled against him. The court upheld his conviction in the statute, obviously taking John Marshall's definition of commerce as intercourse quite literally. And little 3, Congress may regulate activities that have a substantial effect on interstate commerce. Congress may regulate activities that have a substantial effect on interstate commerce. Probably remember here from law school the very famous case from the early 1940s, Wickard versus Filburn. Congress adopted a law that limited the amount of wheat that a farmer could grow for his or her own consumption. A farmer challenged this law and said, what I grow for my family to eat has nothing to do with interstate commerce. This law exceeds the scope of Congress's power and is unconstitutional. But as you know, the Supreme Court upheld the federal law and ruled against the farmer. The court said when it looked at all of the wheat that all of the farmers grew for home consumption, taken cumulatively, there was a substantial effect on interstate wheat prices, a substantial economic effect, so that Congress indeed could regulate. The court applied this more recently, about a decade ago, in a case called Gonzalez versus Raich. There, the court said that Congress constitutionally could criminally prohibit and punish cultivation and possession of small amounts of marijuana for personal medicinal use. Angela Raich was growing marijuana to offset the ill effects of the chemotherapy that she was undergoing. She argued that the Federal Controlled Substance Act was unconstitutional in keeping her from growing and having marijuana for her own medicinal use. But the Supreme Court ruled against Angela Raich and upheld the federal law. The court said, marijuana, like wheat, is a crop that's bought and sold in interstate commerce, albeit for marijuana, it's illegally. The court said, producing a crop that's bought and sold in interstate commerce is economic activity. Therefore, Congress could regulate, could look accumulated across the country, there was a substantial effect. But an important qualification with regard to this rule, and that is, when it comes to non-economic activities, substantial effect cannot be based on cumulative impact. When it comes to regulating non-economic activities, substantial effect cannot be based on cumulative impact. This was the holding of United States versus Morrison in the year 2000. It involved the civil damages provision of the Violence Against Women Act. The civil damages provision of the Violence Against Women Act said that victims of gender-motivated violence could sue in federal court. The Supreme Court declared this unconstitutional. The court stressed that Congress was regulating non-economic activities, rapes, domestic violence. The court said when Congress is regulating non-economic activity, substantial effect cannot be based on the cumulative impact across the country. The court declared this unconstitutional, even though Congress had found that violence against women cost the American economy billions of dollars a year. One other thing is to this last way of finding a law to be within the scope of Congress's Commerce Clause authority. 5 justices have indicated that Congress can regulate economic activity, but cannot regulate inactivity. 5 justices have said Congress can regulate only economic activity, not inactivity. This again goes back to National Federation of Independent Business for Sebelius in 2012 and the individual mandate under the Affordable Care Act. One of the arguments that the United States government made to the Supreme Court was that the individual mandate is constitutional because it's an exercise of Congress's Commerce Clause authority. 5 justices rejected that argument. They said Congress was regulating people who had not purchased insurance. In other words, Congress was regulating those who were inactive. And they said Congress can regulate activity, but not inactivity. Now, I carefully phrased this as 5 justices said this. It was not in one opinion, because 5 justices went on and upheld the individual mandate as an exercise of Congress's taxing power. After all of these recent cases, Congress can legislate under the Commerce Clause in any one of the situations that I just identified. Point 4 under major subpoint A is the 10th Amendment. The 10th Amendment says all powers not granted to the United States nor prohibited to the states are reserved to the states and to the people respectively. All powers not granted to the United States nor prohibited to the states are reserved to the states and the people respectively. Over the last quarter century, the Supreme Court has revived the 10th Amendment as a limit on federal powers. A couple of rules emerge from these cases. Sub A under point 4, Congress cannot compel state legislative or regulatory activity. Congress cannot compel state legislative or regulatory activity. The court has said for Congress to do so violates the 10th Amendment. So, as an example, New York versus United States from 1992. New York versus United States involves the Federal Low-Level Radioactive Waste Disposal Act. It required that every state clean up its nuclear waste by 1996, or it would be deemed to take title to those nuclear wastes and be liable for any harms they caused. The Supreme Court declared this unconstitutional. The Supreme Court said Congress was commandeering the states, conscripting the states, forcing to adopt a law or enact a regulation. The court said this violates the 10th Amendment. Another example of this was a 1997 Supreme Court case, Prince versus United States. Prince involves the Federal Brady Handgun Control Act. It required that state and local law enforcement do background checks before issuing permits for firearms. Once more, the court declared that unconstitutional is violating the 10th Amendment. Once more, what the court said was Congress was commandeering, conscripting the states, forcing out laws, forcing to administer a federal mandate. The court said that violates the 10th Amendment. Congress cannot compel state legislative or regulatory activity. However, important qualification, Congress can try to induce state and local governments to act by putting strings on grants, so long as the conditions are clearly stated, so long as they relate to the purpose of the program, and so long as they are not unduly coercive. Congress may try to induce state and local governments to act by putting strings on grants, so long as the conditions are clearly stated, so long as they relate to the purpose of the program, and so long as they are not unduly coercive. As an example, you might remember that when Congress wanted there to be a 20-year-old drinking age, Congress passed a law that said every state that receives federal highway money as a condition must set a 20-year-old drinking age. Any state that failed to do so would lose 5% of its federal highway money. The Supreme Court in South Dakota versus Dole upheld that as constitutional. The Supreme Court said Congress was not forcing the states to do anything. Congress was seeking to induce the state and local governments to act by putting strings on grants. The court said it was constitutional because the conditions were clearly stated, they related to the purpose of the program, highway safety, and they weren't unduly coercive. There is a case, only one, that's found strings on grants to be unconstitutional for being unduly coercive. Again, it's the case in 2012 about the Affordable Care Act, National Federation of Independent Business versus Sebelius. One provision of the Affordable Care Act said that every state had to cover within its Medicaid programs those within 133% of the federal poverty level. The federal government was to pay 100% of the cost till 2019 and 90% thereafter. The Supreme Court 7-2 declared this unconstitutional. The court said states are so dependent on federal Medicaid money, this is like a gun to the head of the states. The court said the states are so dependent on federal Medicaid money that this is really dragooning the states. The Supreme Court said the condition was so coercive as to violate the 10th Amendment. Sub B under point 4, Congress may prohibit harmful commercial activity by state governments. Congress may prohibit harmful commercial activity by state governments. This was the holding of a case in the year 2000 in Reno versus Condon. Reno versus Condon involved the Federal Driver's Privacy Protection Act, the law that says that State Department of Motor Vehicles cannot release personal information about individuals, like home addresses or social security numbers. The state of South Carolina brought a challenge arguing that it violated the 10th Amendment, but the Supreme Court unanimously upheld the federal law. The court said Congress here was not imposing an affirmative burden on the states. Rather, Congress was prohibiting activity. The court noted that many states were selling their DMV lists. The court said the law was constitutional because Congress was prohibiting harmful commercial activity by the states. The court said that doesn't violate the 10th Amendment. Finally, under major subpoint A, point 5, Congress's power under Section 5 of the 14th Amendment. Congress's power under Section 5 of the 14th Amendment. As I mentioned earlier, Section 5 of the 14th Amendment authorizes Congress to adopt laws to enforce the 14th Amendment. The Supreme Court has said that pursuant to Section 5 of the 14th Amendment, Congress cannot create new rights or expand the scope of rights. All that Congress can do is act to prevent or remedy violation of rights already recognized by the courts. When acting under Section 5 of the 14th Amendment, Congress cannot create new rights or expand the scope of rights. All that Congress can do is legislate to prevent or remedy violation of rights already recognized by the courts. And the Supreme Court has said that such laws must be narrowly tailored. In the words of the court, the laws must be, quote, proportionate and congruent to remedying proven constitutional violations. So the law must be narrowly tailored. The court's words are, it must be proportionate and congruent to remedying proven constitutional violations. This rule was initially articulated in City of Bernie versus Flores in 1997. In 1990, the Supreme Court very narrowly interpreted the protections of the Free Exercise Clause of the First Amendment. In 1993, Congress passed, and President Clinton signed into law, the Religious Freedom Restoration Act. It sought to restore religious freedom by statute to what it had previously been under the Constitution. But in City of Bernie versus Flores, the Supreme Court declared this unconstitutional. In City of Bernie versus Flores, the Supreme Court said this exceeded the scope of Congress's powers under Section 5 of the 14th Amendment. The Supreme Court said Congress was creating new rights. Congress was expanding the scope of rights. Congress can't do that under Section 5 of the 14th Amendment. All that Congress can do is legislate to prevent or remedy violation of rights already recognized by the courts. And such laws, the court says, must be narrowly tailored. The court says the laws have to be proportionate and congruent. But the courts never define those words to remedying proven constitutional violations. Major subpoint B with regard to the federal legislative power, delegation of powers. A few things you should know about delegation of power. Point 1, no limit exists on Congress' ability to delegate its legislative power. No limit exists on Congress' ability to delegate its legislative power. Prior to the mid-1930s, the Supreme Court enforced what was called the non-delegation doctrine. The non-delegation doctrine was a rule that Congress could not delegate its legislative power to executive agencies. But since 1936, not one federal law has been declared unconstitutional as an excessive delegation of legislative power. Every delegation has been upheld since 1937. It doesn't matter how broad the delegation is. Every delegation has been upheld. Just think of the Federal Communications Act. It authorizes the Federal Communication Commission to regulate broadcasting, quote, in the public interest. That's an enormously expansive delegation. There's no criteria to guide discretion, but that delegation, like every delegation, has been upheld since 1936. That's why I say, at least from the practical perspective, no limit exists on Congress' ability to delegate legislative power, such as the executive agencies. Point 2, legislative vetoes and line item vetoes are unconstitutional. Legislative vetoes and line item vetoes are unconstitutional. What's key to remember here is that for Congress to act, there must always be bicameralism, passage by both the House and the Senate, and presentment, giving the bill to the president to sign or veto. For Congress to act, there must always be bicameralism, passage by both the House and the Senate, and presentment, giving the bill to the president to sign or veto. The president then must sign or veto the bill in its entirety. The president then must sign or veto the bill in its entirety. With this in mind, a legislative veto is where Congress attempts to overturn an executive action without bicameralism and/or presentment. A legislative veto is where Congress attempts to overturn an executive action without bicameralism and/or presentment. Congress tries by resolution of one house to overturn an executive action like a new agency rule. There's no bicameralism. There's no presentment. That's a legislative veto. Where Congress tries to overturn the executive action, the agency rule, by a resolution of both houses of Congress. There's still no presentment to the president to sign a veto. That's a legislative veto. Legislative vetoes are always unconstitutional. Legislative vetoes are always unconstitutional. If Congress wants to overturn an executive action, remember it has to pass both the House and the Senate, bicameralism, and then be given to the president to sign a veto, presentment. Anything less is a legislative veto. Legislative vetoes are unconstitutional. A line item veto is where the president attempts to veto part of a bill while signing the rest into law. A line item veto is where the president attempts to veto part of a bill while signing the rest into law. In the mid-1990s, Congress passed a statute that authorized the president to cancel, to veto parts of appropriation bills. The Supreme Court declared this unconstitutional. The court said the president either has to sign the whole bill or veto the whole bill. Line item vetoes are unconstitutional. And finally, point 3 under subunit B, Congress cannot delegate the executive power to itself or to its officers. Congress cannot delegate the executive power to itself or to its officers. Congress cannot give to Congress or to congressional officials the power to enforce the law or the power to implement the law. Those are executive powers, and Congress cannot give it to Congress. So that completes my discussion of the federal legislative power. Well, having talked about the federal judicial power, having talked about the federal legislative power, the third and final power that I want to discuss is obviously the federal executive power. Article 2 of the Constitution defines the powers of the president in the executive branch. I think it's easiest to talk about, to understand executive power by separating the authority for foreign policy from the powers as to domestic affairs. So in subpoint A, with regard to the federal executive power, I want to discuss foreign policy and the power of the president with regard to foreign policy. Point 1 concerns treaties. As I'm sure you know, a treaty is an agreement between the United States and a foreign country that's negotiated by the president and is effective when ratified by the Senate. A treaty is simply an agreement between the United States and a foreign country that's negotiated by the president and it's effective when ratified by the Senate. A few things you should know about treaties. Sub A, state laws that conflict with treaties are invalid. State laws that conflict with treaties are invalid. Example, imagine that the United States and Canada enter a treaty that prohibits the hunting of bald eagles. Imagine that Alaska has a law that allows the hunting of bald eagles. It's clear that the Alaska law would be invalidated. In fact, you might say it would be struck down under the Eagle Protection Clause. Sub B, if there's a conflict between a treaty and a federal statute, the one adopted last in time controls. There's a conflict between a treaty and a federal statute. The one adopted last in time controls. This is a principle that was articulated by the Supreme Court in the 19th century. It's a principle that's been followed ever since. All you need to remember is if there's a conflict between what a treaty says and a statute says, whatever came into existence last most recently controls. In sub C, treaties are unconstitutional if they violate the Constitution. A treaty is invalid if it violates the Constitution. The Constitution, of course, is the supreme law of the land, and nothing, including a treaty, can violate it. Point two, executive agreements. Second thing I want to talk about with regard to foreign policy, executive agreements. Sub A is a definition. An executive agreement is an agreement between the United States and a foreign country that's effective when signed by the president and the head of the foreign nation. An executive agreement is an agreement between the United States and a foreign country that's negotiated by the president, and it's effective when signed by the president and the head of the foreign nation. Notice, no Senate approval is required if it's an executive agreement. If the document is titled treaty, then it can't go into effect unless the Senate approves it. But if the document is titled executive agreement, no Senate approval is required. Sub B, executive agreements may be used for any purpose. Anything that can be done by a treaty can be done by an executive agreement. Never in American history has an executive agreement been struck down for usurping the Senate's treaty-approving power. In fact, there have been times in American history when even major foreign policy commitments have been done by executive agreement. In sub C, executive agreements prevail over conflicting state laws, but never over conflicting federal laws or the Constitution. Executive agreements prevail over conflicting state laws, but never over conflicting federal laws or the Constitution. If there's a conflict between an executive agreement and a state law, the executive agreement controls. If it's a conflict between an executive agreement and the Constitution or federal statute, the Constitution or the federal statute control. Point three, under sub A, with regard to foreign policy, the president has broad powers as commander-in-chief to use American troops in foreign countries. The president has broad powers as commander-in-chief to use American troops in foreign countries. Never, not once in all of American history, has the Supreme Court declared unconstitutional the president's use of troops in a foreign country. That's because the president has broad authority as commander-in-chief to use American troops in foreign countries. Major subpoint B with regard to executive power, domestic affairs. Point one under subunit B, the appointment and removal power. Sub A, who may possess the appointment power? Who may possess the appointment power? Little one, the president appoints ambassadors, federal judges, and officers of the United States. The president appoints ambassadors, federal judges, and officers of the United States. The Senate must approve the nomination for the person to take office, but the president has the sole power to appoint. Little two, Congress may vest the appointment of inferior officers in the president, in the heads of departments, or in the lower federal courts. Congress may vest the appointment of inferior officers in the president, the heads of departments, or the lower federal courts. Notice that the difference between 1 and 2 is that the president alone gets to appoint those who are deemed to be, quote, officers of the United States. But if it's a, quote, inferior officer, then Congress has choices to get the appointment power. Congress can give it to the president, or to the head of the department, or the lower federal courts. The Supreme Court has never clearly defined the distinction between officer and inferior officer. The court has taken a common sense approach. An inferior officer is one who can be fired by an officer of the United States. An inferior officer is just one who can be fired by an officer of the United States. We all learned towards the end of the Bush presidency that the Attorney General of the United States may fire United States attorneys. That makes them inferior officers. Congress could give the appointment power for them to the president, as is now, or to the head of the agency, could give it to the attorney general, or even could give it to the lower federal courts. The Secretary of State can fire an undersecretary of state. That makes the undersecretary an inferior officer. Little 3 with regard to the appointment power. Congress cannot give the appointment power to itself or to its officers. Congress cannot give the appointment power to itself or to its officers. For example, Congress can't say, in creating a federal agency, that some members of the agency are appointed by the president, some by the Speaker of the House of Representatives, and some by the President pro tem of the Senate. Congress tried it, and it was declared unconstitutional. The Supreme Court said Congress can't give the appointment power to itself or its officers. The Supreme Court explained Congress there would be giving the executive power to Congress and its officers, and that violates the principle I mentioned just a few minutes ago. In little 4, the president may not make recess appointments for intra-session recesses that are less than 10 days. The president may not make recess appointments for intra-session recesses that are less than 10 days. This was the holding in 2014 in NLRB versus Noel Canning. There was an impasse between the president and the Senate over the confirmation of the president's nominations for the National Labor Relations Board. And so the president waited until Congress appeared to be in recess and then made recess appointments. The Constitution gives the president the authority to make recess appointments. But the Supreme Court in NLRB versus Noel Canning declared these recess appointments to be unconstitutional. The court says this was an intra-session recess. It was a recess for the December holidays. It wasn't one between sessions of Congress. And the court said the president cannot make recess appointments when it's an intra-session recess that's less than 10 days. So that's point 1 under sub B, who may possess the appointment power. Point 2 is the removal power. With regard to the removal power, unless limited by a federal statute, the president may remove any executive branch official. Unless limited by a federal statute, the president may remove any executive branch official. In other words, unless there's a federal statute limiting removal, the president can fire any executive branch officials. The most famous modern use of the removal power occurred in October 1973, when then President Richard Nixon ordered the firing of then Special Prosecutor Archibald Cox. At the time, there was no statute limiting the ability of the president to fire the independent counsel, so President Nixon had the authority to do so. But Congress, by statute, may limit removal if both of 2 requirements are met. Congress, by statute, may limit removal if both of 2 requirements are met. Little 1, it must be an office where independence from the president is desirable. It must be an office where independence from the president is desirable. So, for example, the Supreme Court has said that Congress can limit removal of the independent counsel, the special prosecutor. The Supreme Court explained that an independent counsel, a special prosecutor, exists to investigate alleged wrongdoing by the president or high-level government officials. The court said the person who's investigating the president and the executive branch obviously, ideally, should be independent of the president. By contrast, Congress can't limit removal of the president's cabinet. The cabinet is there to carry out the president's policies. Congress can't limit the removal because those are not officers who should be independent of the president. And little 2, the statute must not prohibit removal. It can limit removal to where there's good cause. The statute cannot prohibit all removal. It can limit removal to where there's good cause. Even for an office that ideally should be in a pen of the president, Congress cannot prohibit all removal. The most that Congress can do is say removal is allowed only if good cause is shown. So that's point one, the appointment in removal power. Point two, a president has absolute immunity to civil suits for money damages for anything done while in office. The president has absolute immunity to civil suits for money damages for anything done while in office. This was the holding of Nixon versus Fitzgerald in 1982. Ernie Fitzgerald was an analyst in the Defense Department. He testified before Congress about cost overruns in building the C-5 transport plane. President Nixon was furious at him for embarrassing the Defense Department. Nixon ordered Fitzgerald fired. Fitzgerald sued, saying that his firing violated his First Amendment rights to freedom of speech and to petition Congress for redress of grievances. The Supreme Court ruled in favor of President Nixon and against Ernie Fitzgerald. The court said presidents have absolute immunity to civil suits for money damages. They cannot be sued for money damages for anything they do while in office. However, presidents do not have immunity for acts that allegedly occurred prior to taking office. Presidents do not have immunity for acts that allegedly occurred prior to taking office. This was the holding of Clinton versus Jones in 1997. Paula Jones sued Bill Clinton for sexual harassment that allegedly occurred when he was the governor of Arkansas. President Clinton moved to dismiss the suit based on absolute presidential immunity. He said at the very least the suit should be stayed until he was no longer president. The Supreme Court unanimously ruled against President Clinton. The Supreme Court explained that absolute immunity exists to protect the exercise of discretion in office. The court said there's no reason to give immunity for acts that occurred prior to taking office. And finally, point three, executive privilege protects presidential papers and conversations. But such privilege must yield when there's an overriding need for the information. Executive privilege protects presidential papers and conversations. But such privilege must yield when there's an overriding need for the information. Executive privilege is the authority of the president to keep secret conversations with or memoranda from advisors. The key case here was United States versus Nixon in 1974. The Watergate special prosecutor subpoenaed tapes of White House conversations to use in the prosecution of those who've been involved in the Watergate cover-up. President Richard Nixon invoked executive privilege in an effort to keep the tapes of the White House conversations secret. The Supreme Court agreed that presidents have executive privilege. Presidents have the power to keep conversations with memoranda from advisors secret. But, the court said, this power is not absolute. The court said the privilege must yield to when there's overriding needs for the information. The court said the need for evidence at a criminal trial outweighs executive privilege. President Nixon was ordered to produce the tapes. That then completes my discussion of the federal powers, the federal judicial power, the federal legislative power, and the federal executive power.